Hello everyone, let's continue where we left, and we have already almost done 101 questions, and we will continue from question number 102. Yeah, we have done from up till question number 101. We will start from question number 102. The question says the directive principles of state policy are fundamental for the governance of a state. Fourth, yeah, its right answer is option 4. Question number 103. When a writ is issued to an inferior court or tribunal on grounds of exceeding its jurisdiction or acting contrary to the rules of natural justice is called a writ of mandamus or certiorari. Sorry, certiorari. Question number 104. Consider the following statement. The president can commute death sentence to the life imprisonment. The governor cannot commute death sentence to life imprisonment. The president's power to pardon extends to punishment or sentence by court martial. Which one of the statement given are is or are correct? First and third. The president's power to pardon extend to punishments or sentence by court martials as well. So first and third means second. Second is the right option. Question number 105. See, question number 105. Which one of the following is correct statement? Double jeopardy means trying two persons jointly for the same offense, trying the same person for two offenses at two different times, putting the same person on trial twice for the same offense, trying a person for two offenses committed by him in one accident. The right option will be option number third, that is putting the same person on trial twice for the same offense. Question number 106. In case of inconsistency between laws made by parliament and the laws made by the state legislatures, which one of the following shall prevail? The option that we have: the law made by parliament before the law made by the legislature of the state. Option number B. Option number second, the law made by parliament after the law made by the legislature of the state. Third, the law made by parliament before or after the law made by the legislature of the state. Option 4, the law made by the legislature of the state. The right option is option number third, that is the law made by parliament before or after the law made by the legislature of the state. Question number 107. Assertion: the rule making power of Supreme Court is not subject to any law made by Parliament of India. Reason: only an impartial and independent judiciary can protect the right of the individual without fear or favor. A is false, but R is true. Fourth, question number 108. Assertion: the entries in the three legislative list are not always set out with scientific precision. Reason: the entries are not powers but are only fields of legislation. The right option is second, that both A and R individually true, but R is not correct explanation of A. Question number 109. Consider the following statement. The Supreme Court has original jurisdiction in any dispute between the government of India and one or more states. The Supreme Court has original jurisdiction in any dispute between the government of India and any state or states on one side and one or more other state on the other. The Supreme Court has original jurisdiction in any dispute between government of India and any corporation of individual one side and one or more state on the other. The Supreme Court has original jurisdiction in India in any dispute between two or more states. The right option is second, that is the Supreme Court. The Supreme Court has original jurisdiction in any dispute between the government of India and any state or state on one side and one or more state on other. So the right option is second. Question number 1010. No, 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 sorry. Question number 110. Consider the following statement. The High Court has jurisdiction to punish for its contempt. Tender advice on the legal question referred to it by the government of the state. Tender advice on a legal question referred to it by the governor of the state. What? Advice on a legal question. On a legal question referred to it by governor of the state. Governor of the state. Same ही तो है. Tender advice on the legal question referred to it by the governor of the state. Same ही है ये दोनों. Second and third both are same. Fourth one is issue certain writs for enforcement of fundamental rights or for other. Its right option is punish for its contempt. And fourth means first. These two statements are right. Punish for its contempt and issue certain writs for enforcement of fundamental right or for other purposes. Question number 111. Which of the following is not an essential ingredient of a valid arbitration agreement? The right option is the agreement must be registered. The following is not an essential ingredient of a valid arbitration agreement. The agreement must be registered. Question number 112. An arbitration agreement must relate to present dispute, past dispute, present or future dispute, all of the above. Right option is 4, that is all of the above. Question number 113. Which of the following is the material difference between an arbitration agreement and an ordinary contract? Right option is first, both. Right option is third, that is both first and second are correct. Now we have to read the first and second. In ordinary contract, the obligations of the parties to each other cannot in general be specifically enforced, and breach of them result only in damages. The appropriate remedy for breach of agreement to arbitrate is not damages but its enforcement. Right option is third. Question number 114. Mark the correct statement with reference to the Arbitration and Conciliation Act 1996. There is no provision where the party can apply to the court for reference to the arbitration in respect of matter which is covered in the arbitration agreement. Second, the court can only refer the matter to the arbitration when the matter is pending before it. Third, even if the judicial authority is seized of the matter, the arbitration proceedings may commence or continue and an arbitral award may be made. Fourth, all of the above. The right answer is fourth, that is all of the above. Question number 115. Under the Arbitration and Conciliation Act 1996, presiding arbitrator replaces the umpire of the old act. Presiding arbitrator replaces the umpire of the old act. A presiding arbitrator is a part and parcel of the arbitral tribunal, while umpire under the old act was a third person. Third, presiding arbitrator makes award along with panel of arbitrators, while umpire could make award single-handedly when the appointed arbitrators had failed to arrive at a consensus. Fourth, all of the above. The right answer is 4, that is all are correct. Question number 116. Under the Arbitration and Conciliation Act 1996, the mandate of arbitral tribunal terminates when the arbitrator withdraws from his office. The parties agree to terminate his mandate. Incompetence of arbiter. Fourth, all of the above. So the right option is the fourth, that is all of the above. Question number 117. The whole arbitration jurisprudence centers around the whole arbitration jurisprudence centers around the freedom of the parties to agree freedom of the parties to disagree, freedom of the parties to move court for enforcement of award, freedom of the parties to move court for setting aside an award. The right option is first, that freedom of the parties to agree. The whole arbitration jurisprudence center around the freedom of the parties to agree. Okay. Question number 118. In which case the Supreme Court held that power to grant interim measure under Section 9 of the Arbitration and Conciliation Act 1996 extend to international arbitration as well. The right option is first, that is Bhatia International versus Bulk Trading SA 2002 4 SCC 105. Bhatia International versus Bulking Trade. Question number 100. Question number 119. Which of the following statement is correct? First statement is, unless otherwise agreed by the parties, the conciliator shall not act as an arbitrator. सही है. Unless otherwise agreed by the parties, the conciliator shall not act as a representative or counsel of a party in any arbitral or judicial proceeding in respect of a dispute that is the subject of the conciliation proceeding. Unless otherwise agreed by the parties, the conciliator shall not be presented by the parties as a witness in any arbitral or judicial proceedings. Fourth, all of the above. The right option is fourth, that is all of the above. Question number 120. In which case the Supreme Court held that order section 34 of the Arbitration and Conciliation Act 1996, the court can examine the validity of international awards. The right option of question number 120 is first, Oil and Natural Gas Corporation Limited versus Saw Pipes Limited 2003 5 SCC 705. Oil and Natural Corporation Limited. Question number 121. In which of the following cases a partnership exists? Several persons jointly purchase good for resale with a view to divide the profit arising from the transaction. First. Question number 122. In which of the following cases a partnership does not exist? Lender of money receiving profit, servants or agents receiving profits with lender of money, servants of the or agent, widow or children of a deceased partner receiving profit, seller of goodwill receiving profit. The right answer is 4, that is all of the above. Question number 123. A and B entered into an agreement which described them as partners. The agreement provided that in lieu of his share of profits, B was to receive rupees 500 per month and was not responsible for any loss or liability of firm. Later, a dispute arose between two. B contended that he was not a partner since there was no agreement to share the profits of the business. The right answer for question number 123 is B is a salaried partner. Question number 124. You can pause this video and read the other option that I am skipping. So I don't have that much time. I have to solve the further question paper also. So if you want to do read the other option, you can pause the video and read by your own. Question number 124. A partner cannot contract himself out of which of the following duties? Duty of utmost good faith, that is Uberreime Fidei. Uberreime Fidei. Question number 124. Or duty to carry on business to greatest common advantage, duty to render true accounts and full information, duty to indemnify for fraud. So first, second, third, fourth are correct. So the right answer will be first. See, next question. Question number 125. The authority of a partner to bind the firm by his acts done in the usual course of business is called his implied authority. Such authority does not include withdraw a suit or proceeding filed on the firm's behalf. The authority of a partner to bind the firm as his acts done in the usual course of business is called his implied authority. Such authority does not include withdraw a suit or proceeding filed on the firm's behalf. Question number 126. A notice to one partner operates as a notice to the whole firm. Whoever for that, the notice must have been given to a partner who habitually acts in the business of the firm. Notice to a partner who commits a fraud on the firm will not be noticed to the firm. Right option is option 4. Question number 127. In which of the following cases a firm will not be liable for the wrongful act or omission of a partner? A partner of a firm, while acting in ordinary course of business, concluded with a partner of another firm, causing loss to the other firm. Second, a partner acting within the scope of his implied authority raised money by drawing wills in a fictitious name, and he used the money in the firm's business. Third, receipt of money due to the firm by one of the partners by way of set off against his personal debt to the other party. The right option for question number 127 is option number third, that says receipt of money due to the firm by one of the partners by way of set off against his personal debt to the other party. Question number 128. According to section 30 of the Partnership Act, at any time within 6 months of his attaining majority or of obtaining knowledge that he had been admitted to the benefit of partnership, whichever date is later, a minor can elect to become or not to become a partner. Such option is exercised by giving a public notice. If he remains silent and fails to give such a notice, there is a presumption that he wants to be a partner, and on expiry of the said 6 months, he shall become a partner in the firm. If he did not exercise the option, he will be deemed to become a partner in firm. Fourth, all are correct. The right option is 4. That is all are correct. Question number 129. A, B, and C are partners in a firm. C retire and X is admitted in a as a new partner. The firm did not give a public notice to the change but continued its business in its old firm name. Z, a customer of the firm, deals with the firm after the change and firm become indebted to him. Z can sue either A, B, and C, or A, B, and X. According to me, A, B, C, and X. This will third option third is the right answer. Question number 130. The right to resign the contract of partnership is an absolute one and cannot be lost.